this is a sort of a bit of a follow-up event, really, because Di gave us a talk. Di Davis gave us a talk. Must be 4 or 5 years ago now. Soon after the vote to leave Brexit, on the impact he thought it was likely to have on UK law, I think it was at that time, and its impact in Europe. And so now we have left eventually, and he's going to talk about what the impact may be there. Normal things, please keep yourself on mute, as I've mentioned, cameras off if you want, and Q&A to come later. So Di Davis, if you don't know Di is one of our liverymen in the company. I was going to say he's unique, but he's probably not quite unique, but he's extremely unusual in being both a qualified engineer and a qualified lawyer, which gives him an interesting perspective. He has a master's degree in both physics and computer science, but he's a full-time solicitor. That's his role. Previously, he was head of intellectual property law and later national head of information technology law at Evershed Sutherland soliciting firm. And he's now a partner in his own practice, Percy Crowe Davis and Company. He's been consistently recommended in the Legal 500 and Chambers Guides to the legal profession, which probably means more to you in the legal profession than it does to me, but I'm sure it's very important. And as well as technology law and intellectual property law, Di also works in the area of high-tech product safety and security. Right, I think then over to you, Di, please.
So I'm going to talk a bit about information technology and Brexit in the context of information technology. I've actually got a total of 7 topics, and each of these topics I could talk literally for an hour about. So you'll have to forgive this literally race through everything. And if I don't answer all of the questions that you've got, then I'm afraid that's probably par for the course. So I'm going to talk a bit about what Brexit agreements already say. And note the plural there, Brexit agreements, because there are in fact 3 of them. The known divergences between European and United Kingdom law. Again, just a hint at what we already know about the differences. We're going to talk a bit about free movement of software and database rights. Database rights are particularly important in the context of IT. Talk a little bit about GDPR, and I really mean a little bit about GDPR. Jeff mentioned that as well as doing intellectual property and information technology, I also do product safety. And that has to do with something that you may have come across in your life. If you look at the back of your telephone, back of your computer, at the end of this lecture, you can see there's a little C and E mark. That's essentially a European safety mark. So talk a little bit about the freedom of hardware post-Brexit. And very, very at the end, a little bit about dispute resolution and the mess that we're now in. Well, it's not a huge mess, but it is a mess. About the effect of Brexit in the context of contract law and jurisdiction, particularly. So let's start with the first of those topics, which is what the Brexit agreements say about intellectual property, and I'll come to the flags at the bottom in a minute. If anybody's worked out what the right-hand side flag is, you probably all recognise the left-hand side flag. I'm not sure if anybody will recognise the right-hand side flag. We'll be mentioning that in a minute. And as I said, there are in fact 3 agreements. And the reason there are 3 agreements is partly because of various fiddles that the Europeans did. I say Europeans in the middle. I'll explain what I mean by Europeans in that vague tone minute, did it as a means of avoiding having a proper treaty relating to leaving Brexit, which is in fact, of course, the point of the Canadian flag, because the Canadians have a comprehensive economic and trade agreement with Europe. We, by which I mean the United Kingdom, does not have anything like that. And there are reasons for that. The reasons for that are embedded in Article 50. because Article 50 required the European Parliament to essentially approve our agreement. That was expressly in Article 50. And the European Commission didn't want that because they didn't want debates in Parliament about various bits of the agreement. So essentially, the European Parliament was presented with a fait accompli, and the European Parliament, the European Commission equally did not want member states to be able to object to parts of the treaty, and I'll come to that in a minute again, which again is one of the reasons that the way we left was done as a fiddle. And that's quite important because the consequence of that is that it leaves lots of things in limbo, which if we had left in a proper manner, wouldn't have been left in limbo. By which I mean there would be legal certainty, whereas there's now legal uncertainty about a couple of aspects, in very important aspects, I should say, of Brexit. So the first agreement, of course, was signed 24th January 2020, and as you know, there was a big fanfare on the 31st of January 2020 when we actually left, and there was two agreements. These were a fiddle because, as I say, these were the agreements that they said were essentially the Article 50 agreements when they weren't, because they were essentially they acknowledged that Britain was leaving, or United Kingdom, I should say, was leaving, but they didn't actually deal with all of the points which were required for us to leave. And the withdrawal agreement, 24th January 2020, and the corresponding agreement, essentially, with Iceland, Liechtenstein, and Norway, which was essentially a tri-party agreement between the European Union on one hand, the United Kingdom on the other hand, and Iceland, Liechtenstein, and Norway on the other. Why Iceland, Liechtenstein, and Norway? Well, because essentially they are the three full EFTA, European Free Trade Area members. And in fact, quite a lot of the important aspects which are related to intellectual property rights are in that agreement, that tripartite agreement, because previously intellectual property was dealt with not just within the European Union, but within the wider European Economic Area, which consisted of the European Union plus those three countries, Iceland, Liechtenstein, Norway, of EFTA. Switzerland, I'll leave apart, special relationships with Switzerland. And then, of course, we have the agreement that you all know about, the big one, which was a big fanfare, day before Christmas, last year, Trading Cooperation Agreement, 25th of November 2020, which came along with a big fanfare. This is our Brexit agreement. As I say, it is not a comprehensive economic trade agreement. The Trade and Cooperation Agreement, TCA, which has great importance, was never signed and is not a treaty, as is the Canadian treaty, the Comprehensive Economic Trade Agreement, between the Canada on the one hand and every single member state. What we have essentially is an agreement with the European Commission acting on behalf of the European Union. And that introduces lots of issues. The most important is, what is it binding on the European Union countries? And that in itself is a fascinating question. I've asked two QCs, each of whom should know better than I do the answer, and they both point me to a case which is in all the textbooks, but actually the case in the textbooks is not on the point. It's actually a slightly different point. I can't imagine the European Court of Justice ever not agreeing that it is a proper treaty. However, it's not clearly a treaty, and if you, as I have done, had great conversations with at length with German lawyers, it's quite clear that there's ambiguity in the way we've left the European Union, which there wouldn't be if we had a proper treaty. What actually happened with that agreement is that it was approved on the 25th of December 2020 and signed, I think, on memory, on the 30th of December. It was approved by the European Commission on the 25th of December, approved by the UK on the 25th of December, I would say signed on the 30th of December, if I'm correctly, and then ultimately approved by the European Parliament, which didn't have an opportunity to if you like, change it or comment on it. It was eventually approved end of April, I seem to remember, by the European Parliament and approved by the Council of Ministers in May. So it is, if you like, an approved agreement, but it's not a comprehensive economic trade agreement. Why do we not have a comprehensive, what you might think, why on earth do we have not a proper treaty to leave the European Union? Well, the answer has to do with the other flag. I should have asked people actually to put in the chat if you know the answer before I say it as to what this flag is and what these people have to do with us not having a proper trade agreement, or rather treaty, to leave the European Union. Please send your message to Jeff, and no doubt Jeff will tell me at the end if anybody got it before I said it. So the answer is that in order to have an approval, a proper treaty, you have to have, as I said before, indicated the consent of each state. And there was unfortunately a federal part of one state that put its head up about 18 months ago and said, we are not going to approve the UK leaving. And those were the Walloons in Belgium, which is one of the federal states in Belgium. And they publicly said, we're not going to approve it. And that caused a big issue. So what happened in Canada, by the way, is that the Walloons again said, we're not going to approve the Canadians leaving unless you give us whatever. And the treaty with Canada was delayed for 3 weeks while the Belgians paid off the Walloons. I don't know what they paid them off with, but they paid them off. And then eventually 3 weeks later, the Walloons did approve the treaty. But the way the Belgian constitution works is you need the consent of the Walloons, and the Walloons said, we're not going to give consent to the UK leaving. Don't ask me why. I'm afraid you'll have to ask the Walloon Parliament that. So that's why we don't have a proper treaty. But I say there are consequences of that, which we'll see in a minute. So where are we at the moment? Well, European Union law, much of European Union law has been irrelevant essentially since we originally voted to leave. The reason for that is because far fewer cases have been appealed to the European Union, because there was an issue as to whether, were European Court of Justice decisions post our leaving going to have effect? And the short answer is yes, they do, but essentially not an indirect effect rather than a direct effect. We left years ago because 60% of law is European Union law. It takes years usually for European Union law to be formulated and agreed, and therefore by the time we have actually left, which is essentially 31st of December 2020 for all practical purposes, we only have embedded, if you like, in our law, the law that was passed and agreed before the 30th of December 2020. As I said previously, the interpretation of law was on a European-wide basis, the European Court of Justice being the final arbiter. And because we've left, the final arbiter is now the Supreme Court in the United Kingdom. And that, to be fair, was a sticking point, a red line that the government refused to budge on and hasn't budged on. And our final Court of Appeal now is undoubtedly the European Court of Justice. Why a lot of European law has essentially been, I suspect, trashed. And I say trashed because what's the significance of official languages? European Union law is made not in English or French or German, but in every single language of the member states. How many languages are is another question entirely, which I'm not going to deal with at this stage. But the short answer is well over 20 languages. And each of those official languages has exactly the same precedent in European Union law. I can't see a UK judge taking any notice or being persuaded to interpret a European piece of law, which, as I say, 60% of our law is European-based law, anymore on the French version or the German version. It'll be interesting to see if that ever arises in court, but it will do at some point in time. If you can imagine translating that volume of documentation into more than 20 official languages, there are mistakes. And funnily enough, the most common mistake that I've come across is the word or. if A or B or C, then X, which is quite common in any legislation. And you might think, how on earth can that be mistranslated? Well, unless you actually understand what it is you're translating, you can very easily translate that into if A and B and C, then X. In other words, is the or an exclusive or inclusive or? And unless you understand the context, you can mistranslate that. And I can give you examples of that, where you have to look at different language versions to understand what on earth is being gotten at. GDPR has some concepts which just are very difficult to understand. You look at the other language versions and sometimes you can get an idea as to what on earth they're talking about, but because they don't translate one into English. Well, as I say, getting an English court to look at foreign language versions, I suspect is going to be a lot harder post-Brexit. Another classic example of where the legislation, the law is now completely divergent. And again, I'm not, forgive me for not going into this point, which would take 5 or 10 minutes to explain in detail, but is design rights, because design rights, suffice to say, the way that the European Union has historically looked at design rights is completely, and I mean completely different to the Supreme Court in the UK. And there's never been a case taken from the UK to the European Court of Justice to essentially get rid of that divergence. So immediately we're left on the 31st of December. You know, again, this point I have discussed with half a dozen barristers, at least 3 of whom are QCs, and they all agree with me that there's no way that the Supreme Court on that particular case will agree with the European Court of Justice. It's a completely different way that we look at design rights that the Europeans do. So there are changes like that where essentially we know what's happened. There's no way that the UK and foreign, if you like, laws, which are based in theory on the same law, are going to be harmonised, because we have now Supreme Court as final arbiter, whereas in the rest of Europe, the European Court of Justice is now, and always has been, the final arbiter. And there's no longer a possibility of UK legislation being reconciled, if you like, with the rest of the European Union interpretation of what is essentially the same legislation. Let me talk about some software specific issues, because design rights are not really particularly important in the context of information technology. And the first example I'm going to look at is freedom of use of software, which has to do with something called exhaustion of rights. So what do I mean by exhaustion of rights? Well, if you buy a book and you finish reading it, you can give it away, lend it to your friend, essentially do what you want with it. And it's exactly the same with most articles, products, which are protected by intellectual property rights in most countries to a certain or greater or lesser extent. And here we're talking about the intellectual property right, which is copyright, which is by far and away the most important intellectual property right in respect of software, along with confidential information, but confidential information is a different story. So you've got the copyright in a book, say you don't want to read it, you don't want to finish with it, you give it to somebody else, fine. Exactly the same principle applies in respect of software. You have some software, you have a license to use the software, you don't want to use it anymore, that's fine. You can take it off your computer, you can sell it, give it away to somebody else. And that's been not just the intra within the UK law, but it's been the situation throughout Europe. So essentially, there's exhaustion of rights on a pan-European basis. In other words, when I buy some software, and I don't want to use it anymore, not only can I sell it to somebody else in the UK, I can equally well, if I don't want to use it, sell it to somebody else in Europe. And that's been the European law since 1988, if I remember correctly, the year correctly. And essentially it's manifested in UK law relating to putting into circulation copies, which have been previously put into circulation in the UK and the EU, and that's based on a European principle which talks about the computer program having been previously sold in the UK or with the consent of the copyright owner, which comes to much the same thing. So essentially, we have a situation where we had pan-European exhaustion of rights. Now, what's happened with that post-Brexit? Well, as you're going to find out in a few moments, most of this Brexit treaty is not a treaty because most issues are not dealt with. And this issue is a classic example of an issue that's just not dealt with. It's just ignored. What happens, therefore, if you ignore things? Well, you have to look at the underlying law and interpret them. You know what the position was pre-Brexit. You have to interpret it now post-Brexit. So the position in the UK is that we have changed our law, and we've changed our law in lots and lots and lots of ways. I was talking before about product safety, and the product safety regime, we have a regulation which essentially changed the previous legislation, the previous pan-European legislation, and it came into effect when we left on the 1st of January. That statutory instrument is over 800 pages long. I downloaded it once, and it was 10:30 at night, and it said, and it came up with a warning, and it said, "Download in progress. This may take some time." I made myself a cup of tea, came back, it was still downloading. It took 40 minutes to download, and that was 10:30 at night. It's so long. So we made a lot of legislation to, if you like, determines precisely what will happen post-Brexit. In every single case, and I mean every single case, nothing has happened to mimic that in the European Union. So this is a classic example. You have tweaks which have been put into place by the European government, the UK government, I should say, which apply in the UK. But as far as the EU is concerned, they didn't change their law at all. So you just have to interpret the old law. Well, you can interpret the old law quite easily. As I said before, in Europe, there is a pan-European exhaustion of rights. So what does that mean in English? That means that if you're looking at what happens post 31st of December 2020 with software that is first put onto the market today, if it's put onto the market today in Europe, it can circulate freely in Europe, but without anything else, you couldn't bring it into the UK. Well, actually, you can bring it into the UK because we've expressly said in our law, expressly had a statutory instrument which amends previous law, which says essentially in English, we're going to carry on with the same provision. It wasn't put into force for software reasons. It was put into force because the UK wants to carry on importing cheap Greek pharmaceuticals. And pharmaceuticals by and large are cheaper in Greece, and it wants to protect the NHS to be able to import pharmaceuticals into Greece. So it just a blanket for all exhaustion of rights reasons, or for all exhaustion of rights, I should say, or all the areas in which exhaustion of rights applies, that's carried on. So we've got a pan-European exhaustion of rights regime in the UK, meaning that if it's first put into the market somewhere in the European Union, you can carry on importing it to your heart's content in the UK. But because they didn't change the law in the EU, that's not the case in the EU. It applies in the EU if you've got some software first put on the market in Belgium, you can sell it later on in Holland, wherever you want in the EU. But if it's first put into the market or after the 1st of January, on or after the 1st of January this year in the UK, you can't import it into the UK. As far as what's happened before, that carries on, because the question is, and the wording is there, is what happens when it was originally sold that matters. So if it was originally sold prior to the 1st of January this year, we'll carry on as before. But immediate change happened on the 1st of January in respect of software first put in the market in the UK can no longer be imported and sold in the rest of the European Union. And that's just a consequence of the fact they didn't change anything in the EU. And that's part of the cause, as you'll see. Most things didn't change, so you've got to look at the underlying law. The next topic that I want to talk about is database rights. These are, if you like, a made-up European Union right, and I say a made-up European Union right because by and large database rights don't exist anywhere else. And database rights essentially protect the data in a database. So if you can, a good example would be if you have a database of football statistics, you know, how many attempts at the goal there were, who attempted to kick into the goal, what time it was, how many corners there were, how many offsides, a whole database of a football match, or football matches plural. That conglomeration of information is protected by way of database rights. And of course, if you think about information technology, that can be, those sorts of databases can be very valuable. And you can then, if you created such a database, you can control the access to it and rent, if you like, license the access to it. And as this slide shows, the database rights only exists in the European Union, so it's a made-up right based on the European Union directive. There are two ways that European Union make law. One is by way of a regulation. We'll look very briefly at the GDPR in a few minutes, and GDPR is General Data Protection Regulation, and regulations apply automatically, as opposed to directives, and this is an example of a directive. Directives have to be instantiated by a member state. In other words, the directive is a mandate, if you like, from the European Commission, approved by the Parliament, approved by the Council of Ministers, that is then a mandate to governments to change their own law to reflect it. In this case, make up a law called a database right. And it applies where one of the criteria, where the maker or right holder is a national of a member state who has their habitual residence in the territory of the European Union. Actually, it's not just European Union, so most of these rights are extended to the European Economic Area. And that's very important. That wording is critical because, as you can see, I've emphasized the present tense, which is used in that legislation. Our nationals have their habitual residence. Doesn't matter if you're talking about an individual or you're talking about a company. Why have I got a picture of Shell? Well, if you remember, there was a lot of talk about Shell moving its habitual residence, its headquarters, from the UK to the Netherlands. Listed in both countries. In the end, it didn't, and it carried on, and its habitual residence is still in the UK. This issue, like many issues in intellectual property, were dealt with in this EFTA agreement. I told you there were 3 agreements, and this is the second agreement, the one which deals with most intellectual property, because most intellectual property rights apply not just in the European Union, but in the wider Iceland, Liechtenstein, and Norway as well. And this was the one that was dealt with in the EFTA agreement. And what is it actually, what does the EFTA agreement say about it? Well, it said that we carry on as we are until December 2020. And Article 8 and 58 of the EFTA agreement then says that the European Union holder of a UK right prior to the 1st of January shall maintain an enforceable right. But this is, if you like, just a declaration by the Commission, which has been approved. As I say, this is not an agreement between member states. It's merely a wish statement from the European Commission. There's a great question mark as to whether this applies directly into law or not. UK nationals shall be deemed to comply with the requirements of Article 11. Well, hang on, Article 11 says you've got to be a national of a member state. How can we be deemed to be a member of a member state when we're not? Great question as to whether or not database rights have disappeared for English individuals, English companies such as Shell, or not. As I say, there is a case which is similar but not on the same point, which everybody points to, saying, "Oh well, it's going to carry on." And I have to say, it would be a very brave European Court of Justice that decided otherwise. But, and this is a very important but, I've actually looked at the Dutch legislation. I've actually looked at the German legislation. I've had conversations with 3 German lawyers, all of whom saying, you've lost your right to die, because that's not what German law says. German law says it reflects the directive. And French law says that as well, by the French legislation as well. It talks about you having to be a national of a member state, and you're not anymore. Now, the EFTA agreement might give you a right to another right in the European Union law, which I'm not going to bore you with, but essentially it comes down to a right to sue the German government because the German government haven't bothered to change the law. But that's a different right entirely. That's a sort of right in compensation. It doesn't give you a database right. That just gives you a right in compensation because you've lost it. You haven't been compensated. I have no idea what the right answer is in database rights. But what I do know for sure is that because we didn't agree a proper treaty between all the member states, what would have been and could have been precise has now become completely imprecise. And database rights is a classic example. So carrying on with my run through of legislation, let's talk bits and pieces. Let's talk about GDPR. I guess I should explain what GDPR has to do with this picture of tomatoes, which were for sale in my hometown of Sunderland, which is true. And what's Brexit got to do with metrification? If you remember metrification, this was another great European Union scheme. Let's not count things in pounds, shillings and pence. Let's have, actually that wasn't metrification, that was the UK government well before metrification. But if you remember, we changed from pounds for weight to kilograms, and we changed from lengths from miles to kilometers. Well, actually we didn't really. What happened in metrification is that we weren't allowed to use bushels anymore or pounds for weight, but everything that the government had to do didn't change. So we still count our miles on the road, not kilometers on the road, because that would have involved changing a whole load of signs, and the government couldn't be bothered to do that, or didn't want to afford to do that. We still have a land registry, which happily measures things in acres, which the land registry does, by the way, because that was too expensive to change. But everything that the government didn't have to pay for, like signs, people selling apples for pounds, tomatoes for pounds, and people went to prison for having signs like that, by the way, which was an illegal sign because the per pound sign was larger than the per kilo sign. You essentially had to change, or you went to prison. And people did get to prison because they wanted to make a point or not. The GDPR is a great example of why Brexit is like metrification, because we have 82 pages in the approximately 600, 700 word treaty. There's about the same number of words in the annex, but the annex is really, really detailed about things that are not, you don't need to worry about in that sense. It's really the treaty that's important. The 82 pages relating to data protection, well, that's government data protection. That's all about government being allowed to share police databases with other countries. 82 pages. We have 2 pages relating to business GDPR, which is, of course, and that was done literally at the last minute. I say it was done literally at the last minute because it's completely out of place. It's in the middle of financial provisions as section F10A. It's the only section in the entirety of the Brexit treaty that's not numbered, because obviously they did it literally at the last minute and just called it 10A rather than renumber everything. And yes, essentially what it does is it grants what it says that if the UK doesn't change its law, then we'll continue to allow data transfer. And that was provisional, requiring the consent of the European Commission, which had to undertake what's called an adequacy decision, which it subsequently did. And that adequacy decision is now has been formally approved by the Council of Ministers, in place within the time limit they had to do it by, which was the 30th of June. So we have what's called an adequacy decision, but we don't have a proper agreement related to GDPR. So what all the adequacy decision does is allow us to continue exchanging data with the rest of the European Union. It doesn't extend, it's not an agreement relating to sharing data between the two countries as such. It just says, oh, well, you can share data, but you've got to carry on complying with the EU GDPR and carry on complying with the UK GDPR. And you heard that right, there are now 2 GDPRs. There's one in the UK and there's one in the rest of Europe. And you have to apply the GDPR, therefore, twice. You've got twice as much work to do, if you like. Well, not necessarily. If you don't deal with European Union data at all, you don't have any European Union citizens' data. You've only got to worry about the UK. But most businesses who have data not just about the UK citizens, but about European Union citizens, essentially have 2 lots of work to do, whereas previously there were just one. So for one example, one obvious example is that in many cases you need what's called a designated representative, which in English just means somebody to represent you in the European Union. And that also means, by the way, if you're a European Union company and you have data also about UK citizens, you need to have a designated representative here in the UK. It is, if we'd had a proper treaty, you would never have needed that because you would have had a proper means of exchanging data about companies. You would have a proper means of agreeing how the ICO, the Information Commission's Office in the UK, was going to exchange data with the Information Commission's Office in the EU. But we don't have a proper treaty. We've got this very short agreement, essentially, and GDPR's a classic example. You've got the same situation as before. You're just going to look at the law, apply it twice now, in the same way as I gave the example in copyright, exhaustion of rights. You've got no change in the law. The European Union didn't change the law at all. We have, in many respects, we didn't change the law in GDPR. We did change the law, say, in respect of the exhaustion of rights regime. We haven't changed the law in respect of GDPR. So essentially, you've got the same law, but just twice. No agreement as such whatsoever. The only agreement we've got is that we protect, is an acknowledgement, if you like, that we do actually protect data, which is important in its own way, but only in a limited way. Freedom of movement of goods is an even more complicated topic. I actually did an 1.25-hour lecture on this to people who deal with this day in, day out. And essentially, the regime is as follows. But before I tell you what the regime is, I should say why is it relevant to information technology? Well, one of the things that it relates to is information technology hardware. And it applies to any electrical equipment, electrical apparatus. It also applies to any equipment which has electromagnetic emissions, and all hardware, IT equipment has electromagnetic emissions to a greater or lesser extent. CE marking, the product safety regime, applies to a whole host of other products as well, like toys, machines, pressure vessels, but it applies equally in respect of any IT equipment, because not only for low voltage requirements, which is a separate body of law, but also one relating to electromagnetic compatibility. So one of my specialities. And in essence, we had previously to Brexit, quite simple. You go through various hoops, you determine your product is safe, you put a CE mark on it. Sometimes you need to get an external body, third party, if you like, approving, looking over your shoulder, checking you're doing what you should be doing. And sometimes you don't, but you then put a CE mark on the product, and then you can freely circulate within the European Union. Well, that carries on in the European Union, that carries on before. And again, it depends mostly on when you first put the product on the market. So anything that happened before the 1st of January this year, you could still circulate quite freely. So what do I mean in English? You've got a multinational company like Shell, and you've got some hardware in the UK that you don't want in the UK anymore. You can happily ship it, or before the 31st of December, you could happily ship it to the Netherlands or vice versa, ship it from the Netherlands to UK, because once it's been CE marked, once it's been approved as safe in Europe, it's safe for the whole of Europe. However, of course, we now don't have a Europe. We've got the European Union on the one hand and the UK on the other. Hence the UKCA and the UK NI mark. And this is one of course, the bugbears of the treaty, which is the so-called Northern Ireland Protocol, which, yes, I have read because it applies particularly to this area. Again, this is a summary of an hour of what will be an hour and a quarter, but in essence, you've got the CE marking, which applies throughout the whole of Europe. So put it another way, if you are a UK manufacturer, or for that matter, you're an American manufacturer, and you want to sell A in the European Union and B in the UK, there's no longer any transparency, there's no longer any underpinning of standards, because the UK standards and the European standards can go their own separate ways. Actually, that won't happen, but I need 20 minutes to explain why. It won't happen in a hurry. But the reality is you've got a CE marking regime in UK, in Europe, you've got a UK CA mark in the UK, and never the twain will meet, and therefore you have to jump through the hoop twice. In other words, you have to check that your product is okay to put on the European market, CE market. If you need to get a third party involved, it needs to be European third party. If you want to put your same product on the market in the UK, we no longer recognise the European Union representatives, third parties, if you like. You have to get a UK third party to approve that product to sell in the UK, and then you put UK CA mark on. Except, of course, if you're in Northern Ireland, which is where it becomes really complicated, because in Northern Ireland, you're not allowed to put the UK CA mark in. So when I say UK CA, that's rubbish. There is no such thing as a UK CA. Well, there is, because that's the name of the mark, the UK CA mark. It says so in the legislation. But actually, it should be called the GB CA mark, because it only applies within Great Britain, in Scotland, Wales, and England. Because in Northern Ireland, which of course is part of the UK, you're not allowed to use the UK CA mark. You can only either use the UK NI mark, or if you're in Northern Ireland, you're allowed, if you use a non-UK certified body, but a European certified body, you're allowed to put the CE mark in Ireland. But in which case you're not allowed, you're still not allowed to sell it in the UK, but you can sell it in the rest of the EU. So if you're an English manufacturer manufacturing goods or electronic goods only for the European market, because, for example, some stuff is actually different because different voltage for most of the European Union, it actually makes sense to up sticks and go into Northern Ireland, because you can game the system. Unfortunately, there's a bit of the Northern Ireland Protocol which basically says in English, we know that you can game the system, so we might change the law so you can stop gaming the system, but they haven't done that yet. Final comment about Brexit, in case I haven't already confused you completely, is on law and jurisdiction. Hence the pretty pictures, because one is Rome, one is Brussels, and the other is Lugano, all of which three places I'm going to mention in a minute. There are three issues here. If you have any contract with a foreign company or individual, which law applies, which jurisdiction, which courts of which country you're going to have an argument about, if you have to have an argument about the contract, and how do you enforce the contract? Actually, there's a fourth one as well, which is how do you persuade court in country X that you've properly served the document on the defendant if the defendant's in country Y. Actually, that, to a large extent, that last issue has gone away, because most courts in most countries, and certainly in the UK, can be persuaded that if you've had emails for the last 5 years that you've been dealing with Fred, and that's his email address, you can serve the documentation by email if you get a court order to that effect. So service used to be an issue, but in many cases no longer an issue. Governing law is dealt with by the first country, which is Rome, and in essence, there's freedom of choice. Now, remember what I said. For most things in Brexit, there is no agreement. That is not an exaggeration. For most things in Brexit, there is no agreement. Now, that freedom of choice is based upon a European Union-wide convention, which we are no longer a party to, which was the Rome Convention. Now, actually, because of the way that governing law always worked before we had the Rome Convention, even though we're no longer a part of the European Union, in many, many cases, it won't matter. It's reflected in the UK law anyway, and there's very little change because of governing law in respect to governing law. There is in respect to really some weird financial services products, but for most things, because of the way the underlying law was structured even before we had the Rome Convention, both in Europe and in the UK, there won't be much issue in respect to governing law. Jurisdiction enforcement, unfortunately, is not the same. That is dealt with in a different way in Europe. There comes something called the Brussels Regulation, I mentioned before, 2 types of legislation in Europe, directives and regulations which have direct effect. That Brussels Regulation no longer applies because we're no longer part of the European Union. And what that means is that there is an issue, because previously, if you had exclusive or non-exclusive jurisdiction, which is the normal way of expressing in a contract, and I'm not going to bore you except to say that there are many, many circumstances when I'm drafting contract, 9 times out of 10, it's best in a software contract or another intellectual property contract to have non-exclusive jurisdiction. I'm not going to bore you as to why, but trust me on this, it is. And the Brussels regulation said if you had an exclusive or non-exclusive agreement in a contract which said that English law applies, then that's fine, English law applies. No matter if it's exclusive jurisdiction of English court or non-exclusive jurisdiction of English court, that's good enough. Unfortunately, the Brussels regulation is no longer with us, and therefore we have a problem, and the problem is that we're no longer part of Europe. We have to rely on something called the Hague Convention, which is an international convention, despite the fact it's in Hague. It's actually an international convention, and that applies, but only if you have exclusive jurisdiction. So it creates a problem for intellectual property and, as a subset of intellectual property, information technology contracts, because you have to say, if you want to not have an argument about jurisdiction, you have to say exclusive jurisdiction of the English courts, or if you want French courts, exclusive jurisdiction of French courts, to make sure it's going to work. Actually, it should work if you've got a exclusive jurisdiction of French courts, although, again, there's an argument about when it applies to, but I'm not going to bore you about that. There is something called the Lugano Convention, which actually extended this Brussels regulation to the countries I mentioned before, Liechtenstein, Norway, Iceland. And we applied like months ago, a year plus ago, to join the Lugano Convention, but this has become a political football. And basically the European Commission is saying, no, we're not going to let you join the Lugano Convention. There's no logical reason why we couldn't, but they're not allowing us to, presumably because they want to make sure we pay our debts before they allow us to join the Lugano Convention. I don't know for what political reasons, but in reality, that's become our political football, and we now have this problem because they're not letting us join this extended Lugano Convention, which extends the Brussels regulation to, say, Norway, Iceland, Liechtenstein. Well, that is my whiz through the various bits of Brexit that primarily affect IT, and there are others, needless to say, but I'm not going to bore you with absolutely everything.
Well, I'd like to thank Di for your presentation this evening and explaining these evolving areas of law that could affect many of us. The topic of how the law applies to subjects such as GDPR and intellectual property are sort of fairly arcane by the sound of it and complex at the best of times. So throwing into the mix an overlay of EU law can be extra complicated. I think we're probably very lucky in WCIT in having one of our own livery men, or a liveryman as Di is, as an expert with a deep understanding of the actual current laws. So it sounds to me as though the sort of the 31st of December wasn't the end of the whole thing. It's not even the beginning of the end. It's not even the end of the beginning. And I think this story is actually going to go on and on and on. So I'd just like to sort of end and say thank you very much, Di, for a very illuminating and particularly thought-provoking and not least interesting presentation. So thank you very much indeed.